The Best of Our Knowledge explores topics on learning, education, and research. On today's episode, the U.S. Supreme Court recently issued decisions affecting higher education. We'll discuss the decision that struck down President Biden's student debt cancellation program and the ruling that makes it unlawful for colleges and universities to consider race as a factor in admissions. I'm Lucas Willard. It's all next on The Best of Our Knowledge. This is The Best of Our Knowledge. I'm your host, Lucas Willard. The U.S. Supreme Court recently ended President Biden's student loan forgiveness program. At a time when American students face more than $1 trillion in student loan debt, the Biden administration plan, if left in place, would have forgiven up to $10,000 in federal loan debt for those with incomes below $125,000 a year and households that earn less than $250,000. An additional $10,000 would be canceled for Pell Grant recipients. About 40 million borrowers would have been affected. The Supreme Court decision in Biden v. Nebraska hinges on the interpretation of a 2-decade-old federal law called the HEROES Act. To learn more about the decision and the HEROES Act, I spoke with Vincent Bonventre, Justice Robert H. Jackson Distinguished Professor at Albany Law School, who monitors the Supreme Court.
The act was passed in response to, the 9/11 terrorist attacks, the Higher Education Relief Opportunities for Students Act of 2003. And what it did was it allowed the Secretary of Education to, and I'm quoting, to waive or modify any statutory or regulatory provision applicable to the Student Financial Assistance Program under the Education Act. In other words, the student loans. So the big question is, what is meant by waive or modify any statutory or regulatory provision? And those are the words from which, the issue arose.
So I thought it was interesting about just the finding of standing here. There were 6 states that opposed the debt relief measure. They originally sought a preliminary injunction, and that was denied initially, and then there was an appeal. And the court determined at the time that Missouri specifically, and the Missouri Higher Education Loan Authority, which is an entity in the state that services loans, would lose revenue from fees that it collects from servicing these loans from borrowers, and therefore, as Justice Roberts writes in the majority opinion, that the plan's harm to MOLA is also a harm to Missouri. That just brings up the question, how much do state governments actually depend on fees collected from student loan debt?
Right. I mean, this court has not exactly been very generous with regard to standing, that is, with regard to allowing complainants to bring a case in federal court. But in this case, they kind of stretched standing. Now, let's be clear. The Missouri Higher Education Authority was not a party to this case. The state of Missouri was. But the court said, the majority said, look, through this education authority, they're going to lose so much money, and that's money that ultimately the state of Missouri might lose. So, the court really did stretch it. Look, let's face it, the court wanted to reach this question, at least the majority of the court, the 6 more conservative Republican appointees to the court wanted to reach the issue.
Has this become a pattern, or is it something that the Supreme Court has kind of always done when a case reaches their level, that there's an issue that maybe, in this case, the conservative majority has an issue, or conservative Republicans have an issue with outside of the court system, and then that there's kind of some shopping or there's some searching that is done to find a ways to justify removing something or approving something, that sort of direction.
That's right. Look, I mean, you could look at this case as you could look at most cases that come before the United States Supreme Court, right? I mean, these are close cases, okay? These are close cases with strong arguments on both sides. You could be ideologically blind and say, well, this is definitely wrong or this is definitely correct. But the fact of the matter is these cases are close. You could look at what the court does in any of these cases, right? Whether it's the current era or the previous era, you could look at the decisions of the court in a legalistic fashion, or you could look at the decisions in a much more realistic fashion. I mean, the fact of the matter is, if there were a majority of liberal Democratic presidential appointees on the court would have said, no, there's no standing. Or if the court had said that there is standing, the court surely would have upheld what President Biden's administration has done. So, I mean, you know, in all these decisions before the United States Supreme Court, maybe that's overstating it, most of the decisions before the United States Supreme Court have a great political component to them. And so, therefore, you know, when you have a court that is composed of ideological liberals and ideological conservatives, you're going to get an ideological result. And that's just really looking at what the court has done realistically, which is not to say, and I'm not saying that I think the court was necessarily wrong. I would have voted the other way. But I don't think the court was necessarily wrong. I mean, legalistically, they certainly had arguments. I mean, Roberts certainly wrote a perfectly legitimate opinion, but of course, so did Elena Kagan in dissent. And what we have is we have a decision that was favored by conservative Republicans. And I don't mean to suggest that the majority of conservatives on the court listen to what the Republicans want, right? And that's the way they decide. No, but they think the same. Their perspectives on policy issues are very, very similar. And so you're getting results from this current court, just as you would if instead of having justices on the court, you know, you had Republican senators on the court and Democratic senators on the court. You're getting the same kinds of results.
So going back to this interpretation of this HEROES Act, and you mentioned Justice Kagan, who wrote the dissenting opinion in the Supreme Court decision on student loans. Justice Kagan wrote that the new major questions doctrine, as she puts it, works not to better understand, but to instead trump the scope of a legislative delegation. So what is this major questions doctrine that she's referring to?
Sure. And this goes back to one's perspective on the constitutional authority, right, of administrative agencies, right? The constitutional authority of the executive branch, the executive administrative agencies to promulgate measures that really look, smell, taste, and feel like legislation. In other words, really grand measures, or as Chief Justice Roberts says, measures with vast political and economic implications. Now, you know, we all learn in grammar school and high school, you know, that it's the legislative branch that creates the law, that enacts the law, and the executive that enforces. So the major questions doctrine really goes to who has the authority to decide major political and economic questions. And the feeling of Roberts and the majority of the court is that belongs to the legislative branch. On the other hand, Elena Kagan's position and the more traditional position is that we know darn well that Congress cannot anticipate every imaginable contingency. So Congress typically writes a very broad statute, right? Whether it has to do with addressing a health measure, a drug measure, an environmental measure, a worker safety measure, a very, very broad statute. And then it either creates an administrative agency or it gives an administrative agency or some other department of the executive branch the authority to implement that statute, to implement that very broad statute. And so it is the executive branch or an executive administrative agency that then promulgates regulations to carry out that very general, very broad statute. So on the one hand, you have the conservatives speaking through Roberts saying, well, that might be true, but the executive branch of the administrative agency aren't supposed to go too far afield. On the other hand, you have the liberals speaking through Kagan saying, but wait a minute, we allow the legislature to give these broad powers to the executive branch of the administrative agencies because they have the expertise and they're not nearly as accountable to what's popular at the particular time. And so we want them to be independent and we want them to implement measures that really carry out the overarching purposes for the statute. That's the debate.
With the Supreme Court built the way it is right now, with a supermajority of conservative justices, and now we see this series of big decisions right now as we're speaking over the last few weeks with regards to student loans, affirmative action. Does this have an effect on Congress in how legislation is written? Because if I'm a lawmaker and I am in support of a certain issue and I want to make sure that something is fixed, but I don't want it to be struck down by the Supreme Court, then I need to change the way that I'm actually writing the language of the bill. Is this something that you see could happen or has happened before?
Well, the reason why that's a great question is because if you asked Congress, should we pass a law to do what the Biden administration was attempting to do with student loans, Congress wouldn't pass that law. Congress wouldn't pass it. So usually what happens in the Congress is that there are compromises, which generally means that statutes are written fairly broadly, and then it's left up to the administrative agencies, and then ultimately to the courts, and then ultimately, of course, the United States Supreme Court, to determine whether or not what the administrative agencies have done was actually authorized by the legislation. The fact of the matter is, again, the legislation is usually too broad. It's pretty vague. It's pretty ambiguous, just like this one, right? The HEROES Act may waive or modify any statutory or regulatory provision. Could that be construed to allow the Department of Education to waive student loans? Of course it could. To modify requirements for paying student loans? Of course it could. Is that going pretty far? Does that have political and economic implications of such magnitude that it would be preferable if the legislative branch did that itself? Of course. So, I mean, my point is that, you could go either way on these cases. You may have preferences, and the fact of the matter is we have 6 Republican conservatives on the court, and they have Republican conservative preferences. We only have 3 liberal Democratic appointees on the court, and they've got liberal Democratic preferences. But, these statutes right? And what the executive branch of the administrative agencies have done could certainly have been upheld. And certainly it's also legitimate that what they have done could be invalidated. So these are tough questions.
If you were in the Biden administration and you still wanted to see student debt canceled, is there a path forward for that to actually happen?
Well, the Biden administration, I think, would have to take much more incremental steps, perhaps continue to suspend payments, suspend interest, or reduce interest, perhaps reduce payments, but it would have to be incremental. It could not, to get past this court anyway, it could not be of the magnitude of what the Biden administration was doing here. But on that point, I think a major point about all of this is not only what the court did in this case with regard to student loans, but what this court has been doing generally, because what this court did in this case follows a pattern for this court. This is an extremely activist court. And I'm not using that term in a pejorative sense. I don't necessarily think that activism is a good thing or restraint is a good thing, depending upon the outcome that you happen to like. But, in this case, the court was activist in overruling what a president did, what a presidential administration did. In that website designer case, the court, overruled what the state of Colorado had done. In the affirmative action case, the court overruled precedent allowing affirmative action. In the Dobbs case last year, it overruled Roe versus Wade. In the New York rifle case last year, it overruled a state law. In the football coach who was praying midfield, it overruled a landmark non-establishment case, Lemon versus Kurtzman, which has been governing non-establishment for years and years. So this is a very, very activist court. But much like the court in the late 50s and early 60s was a very activist court, and we liberals just loved that court because it was activist in a way that it would issue decisions which we absolutely love, right? Protecting civil rights and civil liberties. So this court is really not doing much more, anything much differently than the court has been doing in the past when the court had a liberal majority. I think we really need to keep that in perspective.
Vincent Bonventry is a professor at Albany Law School. You're listening to The Best of Our Knowledge. I'm Lucas Willard. In addition to its decision on student debt forgiveness, the conservative-leaning Supreme Court also issued a landmark ruling against affirmative action. In Students for Fair Admissions v. Harvard, the court found it unlawful under the 14th Amendment's Equal Protection Clause for colleges and universities to consider race as a factor in admissions. To learn more about the decision and the history of affirmative action, the Best of Our Knowledge's Jody Cowan spoke with Professor Olatunde Johnson, an expert on modern civil rights legislation at Columbia Law School.
Affirmative action is actually a program that started, or a set of programs that started at the federal, state, and local levels to address the history of racial inequality, particularly against African Americans. And a lot of people know about affirmative action because of some of the prominent cases and challenges that came before the court, most notably a case in the 1970s involving the University of California system. That's the Bakke case. But affirmative action is a set of programs that even federal governments put in place to remedy a history of discrimination, for example, in employment, in contracting, and in all sorts of different areas, including education.
And I understand that it's been relatively controversial since its inception.
Yeah, there have always been challenges to affirmative action. And I think those stem for a number of reasons. I mean, I think one is that as a country, we haven't really grappled with our history of racial segregation and discrimination. I think the way the cases are queued up, it always seems as if someone can blame they're not getting a particular slot in a program or some kind of benefit that they were seeking on affirmative action. And so that's how the cases have been queued up. But I think more broadly, what's reflected is a larger inability or reluctance, I think, to figure out how to remedy what are decades and really, hundreds of years of racial inequity and discrimination. So I think that's what that contestation is about.
A bit of a BandAid on a broken leg kind of situation, it seems, in that attempt.
Yeah. Yeah, I mean, I think people often talk about affirmative action as a kind of Band-Aid because it doesn't do everything. I don't quite see it that way. I mean, I think it's been really important and transformative in education, in the medical profession, in healthcare, in contracting, but it doesn't mean that there isn't more that needs to be done.
Who are exactly the Students for Fair Admissions?
So they are really a group that's set up by a long-term opponent of affirmative action, a way of seeing the case that's fairly well documented, and he talks about that himself. Ed Blum, who is the lawyer who also brought the case challenging Section 5 of the Voting Rights Act in Shelby County versus Holder, he brought a subsequent case called Fisher, representing Abigail Fisher, and challenging the affirmative action program at issue in the University of Michigan case. And this is after the Supreme Court had already ruled in Grutter v. Bollinger that affirmative action was constitutional. You had a very strong opinion by Justice O'Connor that embraced the diversity rationale, that said we need as a society to ensure that our institutions are open and that they're legitimate, and they advance diversity. So this was what Grutter held very strongly, with very strong language. But after that, Ed Blum brought the Fisher case and didn't win in the way that he wanted to win. And so he announced that the next category of plaintiffs he was going to have to challenge the affirmative action cases were Asian Americans. And so he found Asian American students. Part of the claim is that Asian American students, at least the category that he found, were harmed by the admissions programs at UNC Chapel Hill and at Harvard. And so that's the new rub, I guess, of this case, is that it involves a different set of plaintiffs. Another new thing about this case is that it challenges what is taking place at a private university. And generally, affirmative action challenges have been against public institutions because private institutions are not covered by the Constitution in that way. But there's a claim under federal civil rights law known as Title VI. And I want to be very clear that the courts below, when they looked at the admissions programs and how they operate in both of these cases, found not only that Grutter should be maintained, right, that affirmative action was constitutional in a general sense, race-conscious affirmative action, but they also found specifically that there was no discrimination against Asian American applicants in the way in which the admissions programs were being operated.
How common are affirmative action practices in higher education and in student admissions?
Yeah, so after the Supreme Court's decision in Grutter, it very much celebrated, as I said, this diversity rationale, but it also made clear that race should just be considered as one of a number of factors in admissions. It shouldn't be done rigidly. I think a lot of people have a memory of or a thought that affirmative action is about quotas or set-asides, where you set aside a specific number of seats, but that's not the way it's done. And so we often call that holistic admissions. We say there are all these qualified applicants, more than we could fit into any school, but how are we going to compose our student body? And and someone's experiences with regard to race discrimination, their racial identity, their ethnic identity, their experiences overcoming racial inequality, or just one of a number of factors in addition to what are the primary factors, which are grades and test scores and student recommendations and other kinds of achievements. And so it's very common that institutions consider this, but it's important to note that 9 states have already banned affirmative action, race-conscious affirmative action in admissions. I emphasize race-conscious because there are other types of affirmative action, you could call them. I mean, a lot of institutions still have things like legacy preferences, or they have scholarship preferences based on merit, and those kinds of things sometimes work to privilege white applicants. The other thing, and I know this is a mouthful, but is that the other thing to note is that affirmative action is really an issue in selective institutions, and most institutions are not highly selective. We're talking mostly about flagship institutions and these kinds of private colleges and universities like Harvard.
What do you think will be the educational impacts immediately on across college campuses?
I think it's really important that institutions be at every level. Okay, so the federal government, colleges and universities, and K through 12 institutions actually shape what is the response to this case. I think it's going to be easy to say that the Supreme Court should dictate what happens with educational policy. It's important that institutions not push back. So do push back on what the Supreme Court has ruled. And so by that, I mean not a kind of defiance of the decision, but maintaining your interest in addressing racial inequality. So when people ask what will be the impact, I think it's up to us. It's up to all of us to determine what the impact is. I think that the underlying problem in this country is not that a few kids are being harmed or by what some people call racial preferences. Far more students are in institutions that are under-resourced, particularly Black and Brown students, including Asian American students who are Vietnamese and Filipino especially. One observer, when we talk about these cases, always mentions that there are more Asian American students at San Francisco Community College than there are at Harvard, and that's a very under-resourced school. So I think what it should call on all of us to do, if we really are caring about creating an inclusive and multiracial democracy in this country, is to work to equalize resources and to create more fairness.
That's Columbia Law School professor Olatunde Johnson speaking with the best of our knowledge's Jody Cowan. This has been The Best of Our Knowledge, episode 1712. The Best of Our Knowledge is a national production of WAMC Northeast Public Radio. Thanks to associate producer Jody Cowan. The latest on all National Productions programs is available via the Airwaves newsletter and our flagship station's website, WAMC.org. Until next time, I'm Lucas Willard.